Hello everyone. So this is my English law channel, and this is going to be a lecture about judicial review with particular regard to unreasonableness as a ground for judicial review. There are various subcategories of the same that we should look into, and we will consider what standard of review is and how there can be different intensities to this. Also look at proportionality, which is something which courts very often take into account. We don't want to do something in a disproportionate manner. All right, so the Westonsbury irrationality. It relates to a 1948 case, Associated Picture Houses Limited and Westonsbury Corporation. So Westonsbury is a small town in England, and the corporation meant the town council, doesn't mean a business. So there was some sort of dispute between the cinema company, picture house, they used to call cinemas, and so they took out a lawsuit against Westonsbury Corporation, i.e. the town council. It was to do with the Sunday Entertainment Act 1932, about what hours on a Sunday you could have public entertainment. These were constricted because of religious considerations. There was the Lord's Day Observance Society saying we must have Sabbatarianism, thou shalt not work or have any entertainment on a Sunday because that's the Lord's Day and entertaining people is working. So anyway, there was a rule saying that people under the age of 15 can't be in the cinema on a Sunday. So, but people over 15 can commit this sin. Anyway, Lord Green was on this case, and he came up with this level of unreasonableness. He said, if a decision is so unreasonable that no reasonable authority could ever have come to it, the courts can interfere. Okay, or elsewhere they said that no person who'd applied his mind to it would have come up with this decision. Well, that's because saying that the town council has no mind. Anyway, it was objecting to that, who was going to be allowed in the cinema on one particular October into that Odeon cinema. So we have to see whether something fails the Westonsbury test, whether it's completely unreasonable. So there necessarily has to be a very high threshold of this test. We don't want the courts intervening willy-nilly. Short and Poole 1926 was an example of this. So let's remind ourselves what the purpose of judicial review is, and that is to look at the substance of the decision-making process and decide whether it was legal or illegal. Often it's not, or sometimes it's not the decision itself, that correct procedure wasn't followed, that people weren't informed of things who should have been informed, that certain things were not taken into consideration which should have been taken into consideration, or indeed you were considering things that you shouldn't have done, things like that. There could be various types of impropriety involved. So what's its effect constitutionally? Well, we have to remember the separation of powers. This is what Ian Loveland, the scholar of jurisprudence, had to say. This ground is more readily regarded as being concerned with the political and moral rather than, in the strict sense, the legal character of the decision concerned. So some people think this is contestable, they dislike it and say they hear the courts intruding on the political sphere. It'd be wrong for politicians to trespass into the judicial sphere, and what's sauce for the goose is sauce for the gander. Anyway, there are some problems in the application of Westonsbury unreasonableness. Is it not a tautology, as in saying the same thing twice? It's difficult to find what are the clear legal principles arising from this. Do they just intuit? Do the judges just claim they know these things instinctively? We can't have judges led by gut instinct. That's just too arbitrary. So there's a lack of lucidity here. It's very unsure what counts as that unreasonable, what doesn't. Obviously, there's always a human element, and it is a bit individual. One judge would say this meets the Westonsbury test, others would say, another judge says it does not. And then surely they're not able to masquerade behind this and actually be advancing their own political agenda. So it's problematic. Anyway, irrationality is another ground for judicial review. There was the celebrated GCHQ case in the early 1980s about people at General Communications Headquarters not being allowed to join a trades union. That's somewhere in southwest England, as in the UK spying on telecommunications and emails now. So Lord Diplock had the following to say about said case. By irrationality, I mean a decision which is so outrageous in its defiance of logic or moral standards that no sensible person who applied his mind to the question to be decided could have arrived at it. Okay, so they think that these people clearly hadn't applied their mind who had come to that decision. So what's unreasonable, what's irrational? I mean, the words seem to be largely coterminous to me. So irrationality is without reasons, as in good or logical reasons. That was as found in R and Devon co ex parte G, a 1988 case decided by Lord Donaldson. Now, irrationality can be a subcategory of unreasonableness. Unreasonableness means not having sufficient proper reasons. That is decided by said in a certain textbook by Wade and Forsyth. So the different kinds of unreasonableness. For instance, there could be deficiencies in the decision-making process, even though this doesn't actually make it illegal, but the court will still intervene and say, no, that's unreasonable, so the decision is overturned. It could be that you gave undue weight to a certain factor, or indeed didn't give sufficient weight to an important factor. It could be decisions which are irrational. Unreasonableness could also mean a decision which is just flagrantly unfair, or it could be a decision which is unconstitutional. It could be that there's an unwarranted exercise of arbitrary power, going beyond what discretion a certain official has. It could be something which is not consonant with other principles or usual behavior without a sufficient reason to depart from usual behavior. It could be something which creates too much doubt and confusion. So let's look at when the decision-making process has gone awry. There could be that they have taken things into consideration, but they've not given due weight to the right factors, and indeed they're given excessive weight to trifling factors. So these decisions are not unlawful in themselves, but you haven't taken things into account sufficiently that you should have taken into account properly. So you haven't weighed these things in the balance as you ought to have done. There was West Glamorgan County Council and Rafferty 1987 about a caravan park. That was a case where that came up. Or there are other examples. For example, Ray Duffy 2008. This was the Northern Ireland Parades Commission. It's a commission which decides which organisations are allowed to march down streets. Okay, these often contentious parades involving the Orange Order, the Royal Black Preceptory, the Ancient Order of Hibernians, the Irish National Foresters, various political parties, and so on. Some of these organisations linked to terrorist groups. The Ancient Order of Hibernians is not, by the way. So people were appointed to that commission who had to decide this parade will be allowed, that one won't, this one will be allowed, but only a certain day, this one can go, but no band, things like that. And so some of the people who were put on that commission were clearly biased. Or there was R and Home Secretary ex parte Cox 1993, another case a bit like that. Okay, decisions which were not rational. And for example, when you haven't demonstrated a clear line of reasoning when you arriving at your decision. For instance, R and Secretary of State for Environment ex parte Fielder Estates 1998, or indeed R and Parole Board 2018. So this is about releasing a notorious criminal called War Boys. So he obviously went in jail for a list of offences as long as your arm. But were they going to set him free? He was a taxi driver who'd raped numerous women, and they hadn't looked sufficiently into his history or other allegations which had not led to charges, and the parole board was going to set him at liberty without doing this. So that was considered to be an irrational decision, and so that was blocked by the court. Or there was R. Rogers and Swinson, NHS, 2006. This was a case about Herceptin. It had not this drug. I think it's a life-sustaining drug for cancer patients, which had not yet been granted a license. So the treatment was available, but only in extraordinary circumstances. So why shouldn't it be more generally available? Or maybe it shouldn't be available at all. Anyway, the health secretary said he had not taken the price of the drug into consideration when arriving at this decision. But Anyway, in an important comparator group, those who would benefit from the treatment would get it. So this woman was denied Herceptin, even though it would be beneficial to her health, but it was not exceptional. So there didn't seem to be any reasonable ground for denying this when others got it, if it was nothing to do with the financial burden involved. Anyway, so but this NHS trust wasn't going to give it to her. So the decision in this by Sir Anthony Clark, who was Master of the Rolls, i.e. head of the Civil Division, this is what he had to say about that Rogers case, Miss Rogers being denied Herceptin. He said, "Where the clinical needs are equal and the resources are not an issue, discrimination between patients in the same eligible group cannot be justified on the basis of personal characteristics, not based on healthcare." Okay, close quotation. So there's a healthcare reason not to give her, that would be all right. It could be there's cost. Okay, we can't afford it for everyone, but the Secretary of State for Health specifically said that cost was not a reason for withholding it. It was something else, and they didn't have a sufficient other reason. You're going to give it to her, but not to her? Come on. If they can both benefit to about an equal amount, then they both got to get it. Okay, there are also decisions which are considered oppressive. There was Wheeler and Leicester City Council in 1985, or indeed R and Secretary of State for the Home Department ex parte Norney in 1995, or R and Barnsley ex parte Cook 1976. Barnsley Metropolitan Borough Council, not a person, Barnsley, a city. So you can question the constitutionality of these decisions, and if they're in breach of such principles, then they could be overturned by the court. If decisions are too arbitrary, then that would go against rule of law. It's just whimsical. No, we can't have that. We don't have rule by fiat. So, and yes, it is true that certain officials are empowered to make decisions, and they have a margin of appreciation. If I was Secretary of State for Transport, I might make this decision. If she was Secretary of State for Transport, she might make the other decision. And it's not necessarily either one is right or wrong. The Secretary of State has the right to make decisions, provided there are good reasons for doing that. There's a arguable case for doing this. There could be an arguable case for doing that. But sometimes you've made whatever decision, but you haven't provided decent reasons for doing so. So if decisions are very inconsistent, they could be struck down. R and Secretary of State ex parte McCartney 1994, or decisions which cause great confusion, as in Percy and Hall 1997. So another example was Bank Mellat and Her Majesty's Treasury number 2. This was about a Middle Eastern bank and where the money was coming in and out. It was the Counter-Terrorism Act 2007, really tightened up transfers of money in and out of the country. And the argument was that some of this money was going to Iran to help them develop a nuclear program which could turn to nuclear weapons. The Iranians always said they never attempted to develop nuclear weapons. And Lord Sumption, who was the best paid barrister in the land for a while, he sat on this case, and he said that the decision made had been disproportionate, it had been irrational, and indeed it had been arbitrary, so it had to be overturned. So we have to ask ourselves what the standard of review is. There's R and the County Council of Sussex ex parte International Traders Ferry 1999. Lord Cook was deciding it, and he set out what the standard of review is, saying it is a decision which would a reasonable authority could reach, close quotation, not would reach, could reach. So there's a possibility that a reasonable authority could reach that decision. A reasonable authority could reach this decision or the other one, but no reasonable authority could reach this decision over here. It's like that. So there could be 2 options or 3 or more, but it's got to be one that you could reach. If you'd have to be unreasonable to decide whatever it is, then that will be blocked by the courts. So let's see how intense the review is. Super Wednesbury, as people say. So that means that we're setting the bar very high to say that it's a Westonsbury irrationality. So the court won't intervene too much on those grounds. You have to really be irrational for them to intervene there. There is a middling level of scrutiny in between, and then there's sub-Westonsbury where there's a lower threshold needed for them to get involved, the court to get involved. Okay, so what's super Westonsbury about? is where there's a low intensity of review. For instance, this is political decision making, and courts are loath to get stuck into the political arena. It can be about the allocation of resources. Again, they would usually say that's a matter for politicians to decide, or something which is really macro level. This is about institutional incompetence or competence, or what's in their rightful power to decide. Also about the separation of powers. What's a judicial decision? What's a political decision? And what's an executive decision? For example, there was Nottingham County Council and Secretary of State for the Environment, 1986. Or R and Secretary of State for the Environment ex parte, the London Borough of Hammersmith and Fulham in 1991. So how about sub-Westonsbury? There are certain fundamental individual rights, and in this case, the courts would scrutinise things very actively. Or there was Bugdeg K and Secretary of State for the Home Department, 1987. Or R and Ministry of Defence ex parte Smith, 1996. Sir Thomas Bingham, he was then Master of the Rolls, i.e. head of the Civil Division Courts, and this was a question of national security, which collided with the human rights of an individual. So which was going to take precedence? Okay, they also look at proportionality. There was Smith and Grady against the United Kingdom, banning something was held to be disproportionate, as in not allowing. I think it was the voice of Gerard Adams to be broadcast because he was advocating for the crimes against humanity. He was trying to destroy democracy, terrorizing people, deliberately killing civilians, killing people on the basis of their religious faith and so on, depriving everybody else of all their rights, trying to kill people for voting, trying to kill people for belonging to political parties, trying to deny them a freedom of conscience and things like that, kidnapping, torture, drug dealing, and so forth. So we have to consider how broadly applicable proportionality is. Some things could be absolute, some things not allowed at all. And then in between, we have to say how proportional is the decision making. For example, R and Secretary of State for the Home Department ex parte Bryan, 1991.